I'm Rupi Rai, and welcome to this second webinar in the PPPs in Sub-Saharan Africa series. I'm based in Washington, and I'll be your moderator for this webinar today. This webinar series is hosted jointly by the Open Learning Campus, the PPP Unit Kenya, and the World Bank PPP Group. Today's topic is the role, impact, and consequences of litigation in Kenyan PPPs. What do we mean by this? Kenya is still in the early stages of implementing a structured PPP program, and litigation is becoming an emerging reality and has both positive and negative ramifications. Specific Petition Committee guidelines were published in 2014 to support its functioning and to guide petitioners and the government of Kenya. They recently finalized Petition Committee Regulations. Given the frequency of litigation, the Petition Committee has been fully occupied with this work basically since its establishment. The objective today is to explore the implications of frequent litigation on PPPs in Kenya. And for this purpose, we have two experts here today with us. First, our presenter today is Dr. Nathan Rono Tuimizing. I hope I'm pronouncing your name correctly, Rono. Rono leads the legal function within the PPP unit of Kenya's National Treasury, where he's responsible for legal and regulatory development, compliance, institutional support, capacity building, dispute resolution, and also he supports the programmatic functions of the unit. Prior to joining the PPP unit, Rono was the deputy head of government legal transactions in the state's law office. Rono holds a PhD and a Master of Laws in International Economic Law from Warwick University and also bachelor's degrees in law from Shivaji University in India. With Rono, joining us today from Nairobi is our discussant, Professor Albert Muma. Albert is a lawyer with 27 years of experience in legal consulting and private legal practice. He's a specialist in public-private partnership arrangements, utilities regulation, procurement law, and environmental and natural resources law. Albert's experience includes assignments in Europe and in many countries in sub-Saharan Africa. He has also worked closely with the World Bank previously, providing transaction advice and developing contract documents. He was also key in preparing legislation in Kenya, including the initial drafts of the Water Act in 2002 and also the Kenya Roads Board Act in 1999. Albert is Associate Professor at the School of Law of the University of Nairobi. On today's agenda is first Rono's presentation, which will take about 30 minutes, and Albert's remarks of about 10 minutes. And we'll then quickly proceed to a question and answer session, as always. Please send us your questions via chat, and we'll be making sure that we monitor that actively. With this introduction, over to Rono.
Good evening, everyone. From Nairobi. Could we have the PowerPoint? Vincent. Okay, great. There it is. Well, thank you very much for joining us tonight. The focus of our conversation today is really to reflect on our PPP experience here in Kenya, but particularly in the context of PPP litigation or litigations that and contestations that have been taking place within our PPP experience. As Rupi very ably summarized, the background to this conversation is the PPP legal framework, which allows for participants in PPP procurement to basically have legal redress in terms of matters that they do not necessarily agree with in terms of administrative decisions around procurement. So what we want to talk about tonight is a few stories coming out of our procurement practice in Kenya in the PPP space, and then spend a few minutes reflecting really on what we are learning from these practices. Maybe before we look at these stories, let me just reflect for a minute on a couple of things. One is that very frequently we are confronted with the reality that the success of a PPP program is usually measured by how many projects get successfully implemented. But because project implementation in the PPP space is drawn primarily from the outcome of procurement practices, and then it goes without saying that the effectiveness and efficiency of PPP project development in any country turns more often than not on how well structured the procurement framework is, and how effective, how efficient, and smooth, if one may say so, the procurement practice is. But secondly, contestation, and in this regard, legal challenge to procurement decisions is not necessarily a bad thing. In fact, we see it as an important element in any good and stable legal system. People need to have recourse. And where there are genuine disputes, people need to have mechanisms for getting those disputes properly adjudicated. But I think, as he said in some contexts, too much of anything is not always necessarily very good. So, in essence, what we are saying is that our experience is telling us that there are things that we need to learn from our PPP practice. There are things we need to learn from our PPP procurement developments. And as we go through that, we will get opportunity today to reflect on some of those issues. So let me give you a bit of a background. The PPP Act in Kenya is about 3 years old. It became effective on the 8th of February 2013. Between then and today, we have launched 7 procurements on 7 different projects. I'll give you a quick heads up in a moment. But out of the 7 procurements, 4 of those have attracted legal disputes and contests in various, frameworks. We've had administrative reviews, basically procurement challenges filed before a procurement tribunal. We've had contestation in the High Court, matters moving either directly to the High Court of Kenya or matters being referred to the High Court of Kenya by way of appeals, following decisions of the Petition Committee, which is the Procurement Appeals Tribunal. We've also had matters getting referred to an integrity oversight institution in Kenya called the Ethics and Anti-Corruption Commission, and we've had contestations before Parliament. So in effect, we are looking at not just legal disputes, and that is why we've sort of entitled our conversation today, Contestation in PPP Procurement. And we are looking at, therefore, the terrain of administrative reviews under the PPP Petition Committee, the tribunal. We are looking at petitions and contestations before the High Court. We are looking at contestations in matters in the context of the Parliament or the oversight framework. And we are looking at contestations in the arena of integrity and fidelity. We'll get back to reflections on what we are learning from all of these issues. So let's look at the procurement. We've launched a procurement for a university hostels project that is ongoing. We've achieved commercial closure. We are working towards financial close. We've launched a procurement, 3 procurements actually, in the energy sector. An LNG power plant project, and the tender failed for various reasons, which are beyond the context of our conversation today. We have launched nearly 1,000 megawatt coal power plant project. We are on course to achieving commercial closure. We've launched a procurement on a housing program for public workers. We call it the Civil Servants Housing Project. It's under contract negotiations. We launched a procurement in a port project, an equip and operate a concession for a port terminal, the port of Mombasa. As a result of contestations, that project eventually got cancelled. We have launched a program under the Roads framework, a composite of 45 contracts, and essentially 17 of them are currently under negotiation, but one was subjected to contestation and was therefore cancelled and ordered for retendering. And the other energy sector project is a geothermal project that is happening in one of our geothermal fields in Kenya called Menengai, and that is currently under contract negotiations. Was split into three specific contracts of 35 megawatts each. Out of the 7, as we said at the introduction of this conversation, we have 4 of them basically attracting disputes, representing technically about 60% of our entire procured portfolio to date. Let's look at what really has panned out in terms of how the contests and legal challenges to some of these procurement practices have panned out. Let's start with one of the projects, Lamu Coal Power Project. This project has attracted 5 different types of challenges. And this started back in 2014. At the point at which the first challenge happened, the focus was on an attempt to basically have the tribunal sent home, if you may. The challenge was that the Cabinet Secretary, which had the statutory power to appoint the Petition Committee membership, acted beyond the powers of the law. We will not get into all the arguments that were presented before the High Court, but the long and short of it is that that petition to the High Court was basically not successful, and the appointment of the Petition Committee membership was upheld. And this was brought at about the same time when the first petition was being submitted to the Petition Committee under the Lamu Coal Power Plant. The specific procurement-linked dispute then followed immediately after the High Court ruling upholding the appointment of the Petition Committee. And that was essentially to say, as a result of the procurement decisions and changes to consortium membership in the Lamu Coal Power Plant bidding framework, one of the bidders had changed members in the context of the procurement process. And the bidder that changed the membership eventually won the tender. And what happened was therefore that the losing bidders, particularly one of them, came up and said, listen, the changes should not have been permitted, and therefore the award to this selected bidder should be annulled because the changes were not supposed to have been made as they were made. There was a lot of other arguments around that particular question. The outcome of that process was that the award decision was not cancelled, it was upheld, but the bidder was unhappy. So he moved to the High Court under judicial review application. What happened was that as a result of negotiations and discussions that followed thereafter, the judicial review application was basically withdrawn by the appellant. So the High Court process was sort of aborted midstream. But that was not the end of the story. Up to that point, we had lost pretty much about 6 months. And then a new inquiry was opened up before the Ethics and Anti-Corruption Commission, again submitted by the losing bidder, and eventually that matter, after about 2.5, 3 months, was eventually closed for lack of credible evidence. But at about the same time that the Ethics and Anti-Corruption Commission was pursuing this particular investigation, a parliamentary inquiry was opened. And when the parliamentary inquiry was opened, the focus was on the value for money, which is a fundamental principle in our PPP procurement, arising from this project. And as a result of submissions that we made to Parliament, the parliamentary inquiry was closed in favor of the projects being allowed to continue. The project today is moving fairly close to commercial closure, and but you can see one procurement process attracting 5 different types of challenges, and that drives fairly significant transaction costs. We'll be talking about a little more about that in a little bit. In the second story that we are talking about tonight, we are looking at the second container terminal project at the Port of Mombasa. These are port concession, an equip and operate concession. It was intended to run for 25 years. But listen to how this thing panned out. This particular one attracted 7 different contestations, and eventually led to the cancellation of this tender. So it starts with the challenge to a non-PPP legislation, which we call the Merchant Shipping Act. The Merchant Shipping Act, under Section 16, basically talks about shipping companies not being allowed to operate port terminals in Kenya. It is a provision that had not been contested before, but at the time we were putting together this transaction, a shipping line that has got interests in Kenya basically filed a constitutional petition, arguing that Section 16 of the Merchant Shipping Act was unconstitutional by basically locking out shipping companies from having interests in port terminal operations in Kenya. And so the orders that were being sought from the High Court were basically that Section 16 should be repealed. That was filed in 2012. In 2016, we still don't have a High Court ruling on that matter. And that tells you a little bit about how long and how complex some of these contestations can become in terms of the turnaround time. Now, we launched procurement before the Section 16 matter was resolved. When we launched procurement, one of the bidders, who was a shipping company, basically went back to the High Court and said, listen, you have not issued orders, you have not determined the initial matter on Section 16. So Section 16 still bars us from participating in this tender. Give us orders compelling the contracting authority, the procuring entity, to accept our bid. And the High Court actually granted them orders, and injunctions were issued because the contracting authority, the procuring entity, basically in this matter, had indicated in the tender documents that shipping lines would not be permitted to participate in that tender. But with the High Court order compelling acceptance of this bid, 3 shipping lines submitted bids. So that was number one. Number two, once the tender evaluation process began, some bidders, as happens in any procurement, did not make the minimum cut in terms of satisfying technical requirements. But then they contested. 3 of them contested. So when they contested, the Petition Committee, which was the first point of call, basically decided that the decisions of the Tender Evaluation Committee was correct. And so the petition failed. When the petition failed, the losing bidders, or the bidders who had been excluded from progression from the technical evaluation stage to the financial evaluation stage, moved to the High Court. And the orders in the High Court, the prayers in the High Court was essentially that this decision of the Petition Committee was wrong, and that it should be vacated, and that their financial offers should be opened up and evaluated like those of the others. The High Court basically decided that the decision of the Petition Committee had not taken into account certain material particulars, so the Petition Committee decision was vacated, and the Petition Committee, being the administrative tribunal of first instance, was told to basically redefine the tender evaluation parameters. That was done. A re-evaluation was done by the contracting authority. That outcome attracted a fresh round of challenges. Now, this fresh round of conflict basically has not quite been resolved up to now. So the first petition happened in the month of July. We're in June 2016, and the conflict is still going on. Because of the gross mismatch between the procurement timelines and the procurement objectives, this tender has eventually been cancelled. But it's been cancelled when we still have a High Court petition pending. We have an appeal before the Petition Committee, and it simply goes to tell you that there are issues around procurement that, when it comes to contestation, that can scatter procurement program in a manner that is never planned for. But as all of these issues were taking place, Parliament opened another inquiry, and this goes to tell you how politically intense these things become, at least in this jurisdiction. Just like it happened in the Lamu coal tender, we have had a parliamentary inquiry into this particular procurement as well. But the parliamentary process, happily, was closed again in favor of this particular project. The focus of the parliamentary inquiry in this particular tender was the value for money angle and the economic advantage of undertaking this particular transaction as a PPP. I think, like we said, we're focusing on the story around procurement, so we will not get into the full details of the actual arguments before Parliament and before the other, tribunals. In another transaction, the issue was essentially that the decision of a tender evaluation committee to award a tender to a particular bidder was not acceptable. In this particular instance, we are talking about a transaction in the road sector. We talked about the roads annuity program. We launched about 45 contracts. 32 of them attracted responses. 17 of them were basically moved into contract negotiations. But in one of those that was awarded and therefore moved to contract negotiations, we had a petition to the Petition Committee. And the committee, of course, basically arrived at the conclusion that the tender evaluation process had apparently not been as transparent and as impartial as it should have been, and therefore the whole process was annulled. And the orders of the Petition Committee was that that particular tender should be retendered. That process is yet to happen, but the outcome was essentially that retendering should have happened. In the geothermal projects, this was actually the first set of petitions that was submitted to the PPP legal framework at the time at which the Menengai 3 geothermal projects were contested by bidders who had lost in the competitively procured process. The Petition Committee was not in place. Now, that was an interesting problem to have because you have a law that set up a petition committee, but at the time at which the contest is happening, that is the administrative action of appointing membership to the committee. Remember the first instance of a challenge to the appointment of the Petition Committee membership. That had not been done. So there was no legal institution that was operational at the time to actually take on board those petitions. So the advisory we issued to the contestants at the time was essentially that perhaps they needed to have recourse to the High Court. Eventually they did not. And the Menengai suite of transactions is basically currently ongoing in the context of contract negotiations. Let's just think through some of the implications. I think we are beginning to see that in Kenya, this business of legal challenges and other types of contestations to PPP procurement is increasingly taking center stage. It's increasingly becoming one of the key determinants to how successful perhaps our PPP program in Kenya will be. As we said, it's currently affecting about 60% of our tendered portfolio. But we are beginning to see a very interesting dynamic, both before the High Court in general procurement litigation and determinations, and arising from the work of the Petition Committee, that there is a very strong emphasis on fidelity to process, on transparency in procurement systems, and on the need to ensure that administrative decisions are accountable. I think that's a very good thing. And it's a very good thing in terms of institutional strengthening. It's a very good thing in terms of driving the mechanics around fidelity in program development. And therefore, with the increasing emphasis on legal recourse, there is, I think, a knock-on effect on accountability in administrative decision making. So that is a good thing. But this word, in my view, I think swings in both ways. It also tells market players that they need to be very fair, they need to be accountable, and they need to ensure that the temptation to use undue influence in terms of determining procurement outcomes is basically not part of the engagement metrics. Secondly, we are beginning to see that contestation and therefore litigation and other types of these challenges we've been talking about is perhaps made a little too easy based on the realities that we seem to be presiding over. Number one, currently, although we have petition regulations that are almost through and we have petition guidelines, we still do not apply any filing fee requirement. So anybody who wants to petition basically walks in, they throw in the petition, and it's free of cost. What that has done is perhaps drive the moral hazard of frivolous litigation. And I think we are learning that is something we need to fix, and we are actually adjusting our petition regulations to address particularly that problem. Secondly, we are seeing an increasing participation of civil society organizations and non-state actors, NGOs, and other parties who are basically strangers to procurement processes, raising issues on matters accountability. And we are talking about the rules of local standi, the right to be heard before petition committee, or before the High Court, or before any other public oversight institution that has been involved in this process. And what that does is essentially to say that the scope for disputing and the scope for disputants in contestation is expanding, and that is a cause for worry. But we are beginning to see also that perhaps the structure of our legal framework may need to be adjusted to address the number of times somebody has to shoot in terms of ensuring that they can actually challenge a process. And two, perhaps there's a little bit of fuzziness in the statutory principles on how tender evaluation criteria need to be tightened up, need to be made more slippery to challenge. These issues are reflections that we are beginning to see in terms of our experience. Number two, the more we have projects getting hung up in the context of contestation, we begin to see a bit of a reputational risk to the program. If projects fail because of too much litigation, then that does not augur very well, because then it has the effect of stagnating our program. It has the effect of basically making this jurisdiction a high-risk jurisdiction for investors. And those are some of the things that we are beginning to see and say, well, we need to begin thinking about how to make the process, one, fair, but two, also ensure that the program remains on course and the country's investment reputation remains credible. I want to conclude with a few thoughts. Number one is that legal redress is a constitutionally guaranteed right. So while we reflect on the challenges that we are seeing from these litigations and other contests, I think we can say unequivocally that we shall defend the right to legal redress that market players have. It is their right. It is something that we must ensure that they always have. Number two, and while we do the first thing, we need to also make sure that our public procurement system works for the people of Kenya. We have PPPs motivated in Kenya's public policy as a very integral component to this country's development. So we do need to make sure that this is a system that works for the people of this country. So we shall defend the motivations and the drivers of our PPP program, just as we defend very strongly the entitlement of people to have legal redress. But as we do so, we are getting more and more informed in our programmatic choices by what we are seeing as arising from the experience of contestation in our practice of PPPs. While we cannot avoid them, we think we have an opportunity to begin to think about how we can prevent them from happening, how we can ensure that those that do come through are the most important, the most serious, the most credible types of contests, and the things that can add value to our legal development in this country. And so we are beginning to think about several options on how to rejig our legal framework. One, lowering the moral hazard that is inbuilt into the current framework of people saying, if it's not me, it's no one. It's a zero-sum game. We think that is not very good for this country, and we are beginning to then think about ways of addressing some of those. And one way to do so is perhaps to rethink about ways to make our legal framework slippery to challenge. We are not yet through with the rejigging options in terms of law reform, but it is something that we are currently working on. But we are also saying we need to make litigation and challenges worthwhile, so that we weed out those that want to basically hamstring a process for no particular major reason. So from shortlisting stages right through to the advanced stages of procurement, we want to calibrate the pain of challenge to make it commensurate to the risks that the program suffers through unnecessary challenges. But we want to do all of this in a manner that ensures that the people that need to challenge these issues are entitled to do so and retain the right to do so. So we want to guarantee and protect the constitutional right to legal recourse. I will be happy to take questions, but after Professor Muma has made his remarks. Thank you very much.
All right. Essentially, mine will be.
We'll give over to Albert for his remarks now. Albert, over to you.
Dr. Ron has made. The general framework, I think, does guarantee that those who have a grievance with the procurement decision should, in fact, be able to obtain redress within the framework of the grievance mechanisms that have been provided. We have, in fact, developed a very robust framework for, redressing grievance mechanisms, and the, avenues that are available have been outlined in Dr. Rono's presentation. One of the things that I would like to highlight is the point that these avenues do encourage, accountability, and it does put some pressure on those who are structuring the procurement, process to actually ensure that it is objective and it's accountable. However, one of the you might say the downsides of that is that it also does open up room for those who would like to hold the entire transaction hostage to be able to do that. And I think that in a number of cases, that is precisely what's happening. And so there are a couple of things that, one needs to pick out and address in trying to strike the appropriate balance between providing an avenue for redress, but at the same time ensuring that it is not used in such a way as to undermine the overall, project. And the real question, I think, is how one can move the review mechanism from a very process-based approach to one in which the review mechanism would look at critical questions about whether or not there is prejudice. And what I mean there is this, that essentially the entire tendering process, the procurement process, is extremely rule-based. There are very many rules. There are very many stages at which documentation is required to be prepared in a particular way. And, from beginning to end, one can almost, take it as given that there will be instances where some mistakes have been made, either in the interpretation of the rules or in the application of the rules, or lapses in terms of not issuing notices on time and things like this, because it's a very involving process, and it's one which is still developing, so that there will be every now and then slip-ups. What those challenging decision of the contracting authority have done is to highlight those slip-ups and use those as a basis of undermining the process. And I think what the review board and the petition committee need to do is really to, inject a sense of realism into the evaluation, and ask themselves what is the prejudice that challenger has suffered as a result of this slip-up. And in many cases, actually, you'll be surprised to find that there is no prejudice, for the reason that the challenger lost, and even if it is subjected to another evaluation, the challenger will lose. So what is missing now in our review mechanisms is that test of prejudice, to say, okay, fine, so you have identified some slip-up. What is the prejudice that you have suffered as a result of it? And in my view, if one does that, then a number of these challenges will fall by the wayside. The other one, which I think, in my view, could be used to essentially try and, move us towards better balance, is the whole question of public interest. Ultimately, many of the projects that we are talking about are projects which fall within the general umbrella of, Kenya's Vision 2030, projects, in the sense that the government is pursuing these projects in order to fit within a wider development agenda, which has certain timeframes. Those timeframes can be thrown off course if you end up with a situation where, due to these challenges, then you cannot meet the timelines, and probably you lose the whole transaction, as has been highlighted in 2 or so examples that Dr. Rono has given. Very many of those projects are projects with that have great significance in the development agenda of the government, and I think that one of the elements of that review mechanism should be an assessment of public interest, and introducing some evaluation of the the kind of omissions or commissions that have occurred in the process of the tendering against the general test of the wider public interest in allowing the procurement process to go through, or in essentially halting the procurement process. Now, when one talks about public interest, it's always the case that there is a concern that it can introduce a cover for, essentially overlooking real, lapses in the procurement process. However, if indeed that public interest test is applied not by the contracting authority, but by the tribunal that is reviewing the decision, and by the High Court, then I believe myself that, being an independent review mechanism, one could use this as a test to try and ensure that you strike the balance. And the third issue, which I think Dr. Rono has mentioned, and which I would like to highlight, is that the current framework that we have is one in which it's open to a very wide range of potential challengers to challenge these decisions, but also there is really almost no financial implication to them for challenging these decisions. The reason being that we do have a constitution which essentially allows public interest litigation to be pursued without cost. So even where the challenger has lost the challenge in the sense that they've gone to the review board, they've lost, they've gone to the High Court, they've lost. In all of those cases, they are not expected to pay costs. There is no security they are expected to deposit. So that has tended to create a situation in which the entire cost in terms of loss of time, in terms of additional transaction costs, and potentially in terms of the loss of the project is borne by the public sector. It's also created a situation in which the potential challenger does not need to think carefully about whether or not they do have a real grievance. In the end, even if they lose, there is really no cost to them. And so I think one of the very concrete mechanisms that needs to be thought about is really to say that, just as is the case with the contracting authority, the challenger also must be prepared to face some costs in the event that they lose. So these are a number of mechanisms, in my view, that one can think about to try and redress the balance, always keeping in mind that a number of these challenges do add value in the sense that they encourage a much more transparent and objective procurement exercise. And that avenue is one, I think, which must always be retained. So the real message here is really to look for avenues of creating a better balance so that we are not swinging either too extremely to one side or to the other. And that, in my view, would be the direction, the way to go in terms of achieving a proper balance in this situation. Thank you.
Yeah. Well, over to you, Rupe.
Thank you very much, Albert and Rono, for your presentations. We've been receiving a few questions, and I'll address two of those questions to you. I hope you can hear me. Guillermo Alboata. It's addressed to Rono. He's asking if value for money evaluation is conducted before or after the selection of PPP projects in Kenya. And are there any prohibitions in the PPP legislation that force the PPP unit or any other institution to evaluate this before any bidding processes? That is one question. How about we start with this one?
Okay. I think we seem to be having an issue with our speaker on this end, but I think the first question is the point at which value for money assessment is made. And I think looking at the structure of the PPP law, value for money assessment are done at the stage of feasibility study review. And that is done before procurement. That is the first stage. We do value for money assessments, affordability assessment, and risk pricing and allocation assessments at feasibility study stage, but we also review the value for money and affordability parameters after contract negotiations, just to determine whether there are any particular or major variances. So that is the stage at which we do those VFM analysis. And we find that they are very useful because they define the extent to which transactions deliver the primary public policy objectives of doing PPPs, which is the delivery of public services, but in a manner that remains affordable and in a manner that supports fair price discovery. Number two, whether we have the opportunity to embed alternative dispute resolution mechanisms in the context of dealing with litigation arising from administrative decisions linked to public procurement practices. My sense is that when you're talking about administrative review for procurement matters, ADR may not be a very suitable mechanism because you're talking about the judicial review of administrative decisions of public actors. When you are looking at accountability in public administration, which is what public procurement does, you are really saying that you need to have a system that allows third parties who are non-state actors in most of these transactions to actually have the decisions of public entities subjected to accountability by way of administrative review. So ADR is not necessarily a very suitable mechanism for dealing with that particular problem. Have I covered both questions, Rupi?
Yes, Rono, thank you. We have another question here. It relates to what you just said. Peter Mabio is asking if you think there are alternative dispute resolution mechanisms that would help solve some of the problems that are currently encountered in the PPP procurement process, and how would we go about using them as an option, and the problems that you mentioned actually would be addressed here, such as reputational risk or the cost of dispute resolution, also the confidence loss that results. So could you talk about alternative options?
ADR options.
What we are saying is that ADR really typically is, it's a process in which you have two parties that sit down and try and strike an agreement. In the context of review of procurement decisions, I think this would create quite a lot of concern among the other bidders. The reason being, you would then have the entity that has made the procurement decision and the entity that is aggrieved coming together and negotiating a solution to the problem. But this then leaves out the other parties who might equally the risk that you could find compromises being struck that actually are against the public interest, in the sense that they agree with this person to say, fair enough, you have the following grievances, but we will strike a compromise. And that compromise may well not be in keeping with the provisions of the law or the rules. So I think myself, ADR is probably not the way to go in terms of reviewing procurement decisions.
How do we
hear them?
All right. Relating to this, there's another question that was sent to us prior to the webinar by Bashir Sadiq Ibrahim. He's asking, can arbitration be deployed in dispute resolution in PPP contracts? And if so, what is the relationship between it and the Petition Committee?
Okay. In PPP contracts, arbitration is actually a standard tool for dispute resolution. Every PPP contract that we enter into has got a dispute resolution clause, and that dispute resolution clause adopts basically the conciliatory approaches: mediation, conciliation, good officers, expert determinations, progressing down to the more adversarial system of formal arbitration. So at the contracted stage, once you have a project under implementation, ADR is a classic and beautiful dispute resolution mechanism. The problem we are facing is really a problem that happens way before we enter into a PPP contract. And we are basically grappling with the challenges of disputing before we have a contract during procurement. And that is really where the problem is. And that is what my senior colleague, Professor Muma, has just mentioned, that ADR would not be very suitable for disputes management prior to contracting. After contracting, that is absolutely fine.
Thank you, Rono. We have another question here. It relates to the example that you mentioned, Rono, during your presentation about the shipping company. The question is regarding the shipping lines and the operation of container terminals. Is the statutory bar on this informed by competition policy, even if in part, and if so, are competition agencies involved in that petition?
Sorry, could you repeat the question, Rupi?
Absolutely. The question was regarding the shipping lines and the operation of container terminals. Is the statutory bar on this informed by competition policy? And if so, are competition agencies involved in that petition?
Good question. That's a very good question. Thank you. Yes, it is partly informed by competition policy, but it's also partly informed by the local realities in terms of the role of local market players when it comes to port business operations. So the whole idea was basically to minimize vertical integration and promote opportunity for local market players to deal with the dynamics of inland business. Let me just give you a little background to that in about 30 seconds. One is that the organization of port business in the Kenyan maritime trade framework is essentially that you have companies setting up inland container depots that are called container freight stations. So you get your containers handled and processed by the Port of Mombasa, but because the ship-to-shore interface is fairly quick, while the shore-to-land interface is not as quick, what that had created was heavy port congestion with a port dwell time sometimes of up to 20-21 days. The objective that was then pursued was to try and improve turnaround time. And one way to do so was to basically get the containers away from the port into container freight stations that would allow then importers to offtake their cargo at a time that was comfortable to them. What that developed over time was a negative practice where you have shipping lines having a big interest in the offtake systems, and therefore issues of market reconfiguration informed a bit of the structure of the initial Section 16 of the Merchant Shipping Act. So yes, competition policy was part and parcel of it, but no, competition authorities are not part of the current constitutional application before the High Court. It's basically just the shipping lines versus the Attorney General and the Kenya Ports Authority, which is the institution implementing this transaction.
Mm-hmm. Thanks, Rono. I have a question for Albert. It was also sent to us prior to this webinar by Pramod Kukil. He's asking a question about risk allocation and how risk allocation in PPPs can be determined and framed in the contract to mitigate litigation beforehand. So what would be the general best practices that you could talk about regarding risk allocation to avoid litigation?
In the contract, well, I think in the contract the risk allocation is, there is provision within the PPP framework for how one would allocate risk, and the general principle is that the public sector essentially seeks to transfer as much risk as is feasible to the private sector, but it will be negotiated so that you end up with a situation where for some transactions, in order for that transaction to be viable, the public sector will take up some of the risk. And then, of course, if that is negotiated and is in the contract, then, the way that one would then deal with it if there is a dispute is through the provisions in the contract for dispute resolution. But it's not possible to use that as a way of resolving the disputes that arise during the tendering process. Because during the tendering process, essentially the basic position is that the the public entity that is procuring the PPP contract essentially will have the right to proceed with it or not proceed with it. And in terms of the tendering, the private sector tenderers will absorb the risk in the event that it is cancelled. So, and of course, the public entity also picks up the entire risk in the sense that should there be a successful challenge to the procurement process, then they are required to retender, or indeed the whole thing is cancelled, they absorb that risk. So prior to the actual contract, I think risk allocation is really a black and white affair in which you have the public entity face the risk that if they do get a successful challenge, they lose that particular tender and they may have to start again.
Mm-hmm. Thanks, Albert. It really seems like it's a balance that needs to be achieved between allowing legal recourse and avoiding lengthy litigation and petitions. Thank you, both of you, for your time, for your presentations and your remarks, and for a lot of time already. Really thank you for this informative discussion also, and to the audience for posting your questions. The recording of this webinar will be available 24 hours from now. I would ask you all to please take this survey at the end of this webinar. Please give us feedback on what we can do better, what you would like to see in the future. And the next webinar of the PPP group is going to be on June 28 on communications and social license issues in Kenyan PPPs. We hope you will join, and thank you.